I would like to now call Ms. Heather Fast. Oh, can I stand? Oh, no, it's okay, sorry. Ms. Fast, please go ahead with your presentation.
Thank you. Good evening, everyone. My name's Heather Fast, and I'm the Policy Advocacy Director at the Manitoba Eco-Network. The Manitoba Eco-Network is a nonprofit registered charity which seeks to strengthen Manitoba's environmental community with the goal of protecting our environment for the benefit of current and future generations. I'm a lawyer and a legal academic who spent a long time working with the grassroots community to find ways to improve access to justice in Manitoba. So I'm extremely pleased to be here today to support the passage of Bill 23, the Public Interest Expression Defense Act. Bill 23 will create a new legal pathway to protect citizens speaking up about matters of public interest and discourage the use of litigation as a means of limiting discussion and debate. This type of frivolous lawsuit is also often referred to as a strategic lawsuit against public participation or a SLAP suit. Anti-SLAP legislation like Bill 23 is an important mechanism for improving procedural justice, ensuring those advocating for public interest do not feel intimidated or afraid to speak up. I've been seeking the adoption of anti-SLAP legislation in Manitoba, modeled after the ULCC and Ontario's Act for many years, both through my work at the Manitoba Eco-Network and my academic studies as a PhD candidate, which have focused on identifying legal mechanisms that can be adopted at the provincial level to facilitate access to justice for Manitobans. Unsurprisingly, anti-SLAP legislation is often recommended as a means of protecting citizens from frivolous lawsuits. Community members have spoken with the Eco-Network about their fear of legal repercussions for speaking up about public interests. For example, we've heard from citizens who've received cease and desist letters for making a Facebook post about their environmental concerns. Many citizens will discontinue their advocacy activities when faced with the legal threat, as the potential legal and financial burden is extremely overwhelming. The adoption of anti-SLAP legislation like Bill 23 will help strengthen the ability of Manitobans to advocate on behalf of themselves and their communities without facing severe legal and financial consequences. Anti-SLAP laws help protect vulnerable citizens, such as survivors of gender-based violence, when they disclose or report the violence they have experienced. Anti-SLAP laws also protect those who study, report, and publish about matters of public interest from being intimidated or silenced by costly, time-consuming lawsuits. The Manitoba Eco-Network has had a number of great discussions over the last few years with the Department of Environment and Climate Change about our policy and law reform recommendations and the need for anti-SLAP legislation such as Bill 23. We appreciate the time that's been spent listening to us, both by Minister Schmidt and Minister Moyes. Bill 23 has also given the Eco-Network the opportunity to build a new connection with Minister Wiebe and his staff at the Department of Justice and discuss our thoughts on the bill. It's nice to feel heard by the Manitoba government and see action being taken to protect public interest advocates. However, there is one big problem with Bill 23 that I hope can be fixed today. Section 4.2 of Bill 23 could result in situations where, when a legal proceeding involves an injunction, the filing of a dismissal motion under Section 3 of the Act will not pause the proceeding, even if the injunction ends up being meritless. We think this exception weakens the protections offered by the bill. There should be an opportunity for the proceeding to be paused, even when injunctions are involved. As a result, we recommend removing Section 4.2 from the bill. Our engagement with Minister Wiebe and his team seemed to demonstrate a clear interest from the Department of Justice in improving protections for those speaking up about public interests. Next week, when I deliver the lecture on public advocacy to my law students that I rescheduled to be with you here today, and we watch this recording in class, I hope I'll be showing them an example of democracy in action, of elected officials actively listening and changing proposed legislation to better protect Manitobans. We want to see a version of Bill 23 that aligns with the approach used in the ULCC and Ontario Acts, meaning no Section 4.2, to ensure there are no gaps in the protection of individuals and organizations speaking up about matters of public interest. Although the version of Bill 23 that was introduced is not perfect, if I was marking it in my class, I'd give it maybe C+ or a B. It's my hope that we will see the removal of Section 4.2 of the bill today, so I can assign the Public Interest Expression Defense Act the grade Manitobans deserve, which is a big fat A+. Thanks for your time and consideration of my remarks.
Thank you so much. Minister Wiebe?
Yeah, thanks so much, Ms. Fast, for your presentation. Looking to get that A+ tonight, but I appreciate it. You know, your support really means a lot, because not only are you representing the Manitoba Eco-Network, who lives and breathes this reality every day and really tries to navigate these issues, but your academic work has really lent a lot of credibility to this issue as well. We appreciated the meeting and the opportunity to talk through some of your concerns around Section 4.2, and yeah, we're looking forward to working with you. And thank you again for your presentation, and thank you for the students who are following along and going to watch this later. We hope to see them in committee following your lead and participating in democracy.
Thank you, Minister Wiebe. Ms. Fast?
Thanks. I hope to be back, and hopefully in the future, I will be Dr. Fast instead of Miss Fast, and you can hear about my study results.
Thank you. Anything else? Mr. Balkin?
Well, thank you for your presentation and again, doing the advocacy. I also look forward to seeing the students here in the future, because that's what this committees are about, is having that. And it was good to hear finally a passing grade for this government. So, thank you.
Ms. Fast?
Thank you.
Ms. Fast? Yeah.
Thank you. And I appreciate your comments you've made today about the importance of hearing from the public. I very much agree.
Thank you. Any further questions? Ms. Cable, or Minister Cable, my apologies.
Thank you for coming here today, and thank you for being such a phenomenal example to your students. I think that it's so important that we have instructors, professors, folks in positions like yours doing the good work of showing students exactly what this looks like in action. So thank you so much for doing that.
Ms. Fast?
Thanks, and I'll do my best to prepare them for when they come speak to you.
Wonderful. Thank you. I would now like to call upon James Beddome. My apologies if I mispronounced your name. Perfect. James, please proceed with your presentation.
Thank you very much to the committee. Thank you very much to the chairperson. I'm very happy to be presenting here today in support of Bill 23, the Public Interest Expression and Defense Act. I also am going to echo, and I will get into that momentarily, echo some of the comments of the previous presenters that I believe that subsection 2 of section 4 should be removed from the bill. But overall, this is a good bill. I do want to address an opening matter, which been lucky enough to present many times to this standing committee. This is a somewhat unique process in Manitoba. I think only one other province in Canada has the process where anyone in the public can come in, and I think we've heard some great comments today, so I'll make a suggestion, which is, I believe the legislative rules provide 2 days minimum notice for getting a standing committee together. I would suggest upping that to a week so the members of the public can have more time to prepare better submissions and better participate in this process. So just as an opening matter, I want to put that on the record once again, and I hope this might be the last time I have to put it on the record, because I see changes as a result of that. Now, once again, this is a good bill. It serves to create a legal tool to reduce the risk that legal action will limit the expression that relates to matters of public interest. I'm speaking today as a private citizen, but I will state I'm called to the bar in Manitoba, and prior to a recent career shift about a year ago, I spent 10+ years working as a lawyer, primarily in litigation. Couple of adages that I found myself constantly telling clients over my decade long of practice was, there's no justice in the justice system. And the sad reality of that is sometimes it's a reality that we need changes in the laws, but more often than not, it's the reality of the inequity in the justice system. This bill isn't going to solve massive economic issues, but the reality is the justice system is hugely inaccessible for people. 10, 25, 100,000 goes very quickly. It's just the reality of it, and it makes it inaccessible. I remember advice that I got as I was about to go to my articles from a lawyer was, realize how expensive we are. Even most lawyers can't afford to hire lawyers. So the reality of our justice system is that very often it's for large organizations and very wealthy people. And that's something that this bill provides a small tool that will help improve that. Another adage I often ended up telling people is, even if you ultimately win the suit, just by being sued, you lose in many respects. Once again, that's a cost issue, right? Because the reality is, once you're served with a claim, you have to respond. If you don't respond, default judgment will likely be rewarded against you. The other party's going to get what they want. And even if you do respond and you fight the suit, the reality is that typically costs are awarded on what's known as lawyers call a tariff basis, which means in accordance with the cost tariffs laid out in the King's Bench rules. And you can't say for sure, it depends on how many hours the lawyer will take, but I would suggest that typically that's about half to 1/3 of the actual costs that people incur. And this is why I think in some ways this bill provides some good provisions, specifically Section 6, which provides costs on a full indemnity basis, which means a 100% basis. It also allows for discretion of judges to adjust that award as they see fit. And I want to highlight the discretion of judges because I think that's very important. I want to make it clear that, I want to get ahead of any the sky is falling arguments that might appear, right? Judges are highly competent in Manitoba. They are good at assessing claims, determining the merits of claims. That's what they do. So I think we need to realize that. And I think realize that, entrust our judges to have that discretion. And this bill simply creates the option of moving forward with a motion to dismiss a proceeding where the judge on balance, it's outlined in section 3, I believe, where they sort of outline the balancing weight that the judge is going to take to look on balance. The purpose of this proceeding, is it intended to suppress public expression? Now, I will say that subsection 4.2 should be removed. And I think in addressing that, I want to highlight how injunctions typically proceed, because this doesn't mean we will never see any injunctions. This doesn't mean we won't see people having legal protections. There is simply an additional tool, an additional motion that people can avail themselves of if they're going to move forward. But Rule 40 of the Court of King's Bench rules stipulates how an injunction may proceed. And although it doesn't always happen, I will suggest more often than not, injunctions proceed on a without notice basis. That's more common than not. So what that means is that the other side isn't there. It's an ex parte proceeding, so the other side doesn't get to make their arguments. And now, although lawyers, we have an obligation to be truthful and honest to the court, we also have an obligation to advance our client's interest. So you can probably understand in an adversarial system when one side presents arguments, the other side doesn't. It makes this certainly creates some procedural inequity. Then a party typically, once they've got that injunction, now they need to respond. They need to deal with the injunction, how it's going to be dealt with. The main action or application, as the case may be, that originates the proceeding is honestly very often nominal. It wouldn't make it into King's Bench in terms of quantum of damages. They're usually trivial suits in nuisance or trespass or maybe detinue. There may be issues of publication. I can't comment on specifics. Each case is unique to its own. But the reality is that the actual claim itself is generally very nominal. And so that's why it's important that subsection 4.2 be removed, because that injunction itself would be a way to continue to drain a party's resources. It in many ways is nonsensical with the over-intention of the bill. And all it would mean is that the party that then has that injunction would then end up having a motion where the judge would ultimately decide the entire proceeding, whether it has merit or not, and whether the intention of it is to suppress public interest. Ultimately, I just wanted to sort of outline that sort of procedural aspect so that I think members of the legislature understand that. This isn't going to change the world, but it is going to make a meaningful impact. It is going to create an option for people when they're facing what is colloquially known as SLAP lawsuits, strategic legal actions against public participation. And it has broad-reaching impacts, as we've heard tonight. Labor disputes and injunctions on labor disputes, environmental issues, publications, broadcasters, journalists, abuse survivors. There's a broad range of categories. Politicians, right? I mean, you were all lucky enough to benefit from parliamentary privilege when you speak inside the legislature, as are parliamentarians in Ottawa. However, municipal councils don't have that same benefit. They don't have that same protection. You may not have that same protection if you're acting outside of your course of official duties and speaking in the legislature. So this has broad-ranging impacts, and it is a good bill, and it will be made a better bill by removing subsection 4.2, and I hope this government passes it. I hope we see this government pass it unanimously, which is what we saw in BC. It shows that there is a strong unanimous support to a meaningful bill, and it would mean Manitoba would be the 4th jurisdiction, as I understand it, in the country, following BC, Ontario, and Quebec in implementing anti-SLAP legislation protection for the citizens of Manitoba. Thank you very much. Subject to any comments you may have.
Thank you. Any questions? Minister Wiebe?
Yeah, thanks very much, Mr. Beddome. Very good to see you again. I appreciated the thorough analysis that you brought to the committee tonight. That kind of insider's perspective, I think, is really helpful for us to understand, you know, the impact that this can have in protecting those folks who are vulnerable. And I appreciate your support of this. Again, we met earlier. I'm happy to listen to your concerns around 4.2. Just as a note, you know, this is one of the bills that was delayed by the opposition, and so yeah, I think it's a good question. You know, whether there will be a unanimous support. I hope that there is as well.
Thanks, you, James.
Yeah, I also hope there'll be unanimous support. It's why I actually, you know, I thank you for your meeting and took an attempt. I hope it's okay to speak to the other side, so to speak. I hope we don't see it that way, because it's about Manitobans, but about understanding the implications of this bill, and that I also want people to understand that as I said, it isn't Chicken Little. The sky isn't necessarily falling. This isn't gonna, you know, it isn't. It's huge. It's important, but it's not. It's not going to change everything. It's not going to change the world. Systematic inequality is still going to exist. We're going to have to make, you know, massive improvements on our economic system, a number of changes, but it is a meaningful tool. So I hope, like you, we can see unanimous consent for this ultimately.
Thank you. Mr. Balkin?
James, thank you very much for your presentation and really putting an expert spin on this for us, and bringing that forward. It, you know, it's actually very persuasive, some of your comments that you're making here, so we thank that. And I'll just add to what the minister said, is that yes, we did hold this bill back, and specifically for the reason that we wanted to make sure it was right. We wanted to check with the experts, and we wanted to check with people within the law and citizens that are being affected. So, you know, it's important to make sure we get this right.
Thank you, Mr. Balkin. James?
Definitely, I agree. It's important we hear this right. I think it's important we hear from Manitobans, which, you know, I made the comments about the process, and so I don't know. I guess I don't really get to ask the questions, but I'm going to ask one anyway, which is sort of, will we be seeing unanimous support? Has decisions been made now that enough time has been there to reflect and consult with experts?
Thank you. Any further questions? Seeing none, thank you for your time.